Protection of Women from Domestic Violence Act 2005. This is one important legislation which has come into existence specifically basing on the international convention, the CEDAW convention, where it says that there are several laws are given to the woman specifically to protect her from various spheres, like the penal legislations are there with regarding to the Indian Penal Code, where the woman was given a right to get any kind of an offense which is against her, she can file. But only the problem, till before 2005 there was no legislation which basically spoken with regarding to the domestic front, because it is shown that the statistics says that 51.4% of the crimes against the women are relating to the domestic crimes. So, when you talk about the National Crime Report, when it has given, it says that out of all the crimes committed against the women, the important crime where we look into is the domestic crimes. Now, majority of the victims with regarding to this domestic crimes are daily wage laborers, followed by the housewives. So, at the household, the women are being tortured under this concept of the domestic violence. Likewise, when you look into it, 47.27% of the victims are those people who are having a monthly earning is between 1,000 to 5,000 rupees. Now, only 16.36% of the victims belongs to the income group of 10,000 rupees category. So, when you look into this particular statistics, it very clearly says out of the 51.4% of the women, when they are being tortured with the domestic crimes, most of them are below the the income group of below 5,000 and the housewives. Now, 73.9 victims are married and only 15.5 victims are single or unmarried. So, this has been shown the importance, and the BBC once mentioned that every 5 minutes an incident of domestic violence is reported in India. So, when you look into this particular statistic, it is really heartbreaking, saying that when the woman today is in all the spheres, she is being a part and parcel of the socio-economic development of the state, and she is striving for her equality, and she is taking up into the various projects and all. But very sadly, where you could see that there was no law before 2005 to protect her interest and to protect her, the offences committed by her own family members. So, in order to bring out all these, and this act basing on the Domestic Violence Act 2005 has passed with a basic mandate or objective behind passing it is in order to give a mandate of protection to the women under Article 14, 15 and 21. And specifically when you talk about Article 21, that is the right to life and liberty, they said that right to free of violence against the woman is one of the attribute of life and liberty. Then right to enjoy the life, stay in a dignity also was treated to be a part and parcel of Article 21, and right to shelter. One of the basic mandates of every human being is food, clothing and shelter, but for the woman shelter is very, very important. So, in order to protect the woman specifically where she can enjoy her life without violence and stay with the dignity and at a house that is her place where along with her family she can enjoy, these are the basic important mandates why this act came into force. Now, when you talk about the scheme of this act, the act came into force on 13 September 2005, where the act consisting of 36 sections which are spread over 5 chapters. Now, chapter 1 basically gives you preliminary, that is what is the extent of this particular act, and important definitions which are given under section 2 of the act. Chapter 2 basically talks about the definition of domestic violence, what amounts to what extent the domestic violence is. Then chapter 3 talks about the powers and the duties of protection officers, service providers, etc. So there are several authorities laid down under this act. What are the powers and duties of these officers and the service providers are given. And finally, chapter 4 says about what is the procedure, how a woman, if at all she has been tortured at her place or where a domestic violence is committed against her, what is the procedure and what kind of orders and reliefs she can claim for protection of herself. And finally, the powers of the state and central government with regarding to the better implementation of this act under the chapter 5, that is miscellaneous. So this is the scheme of this act which has been passed in the year 2005, that is 13th September 2005. Section 2 basically speaks about the definitions. Out of all the definitions, I would like to talk about 3 important definitions. One is aggrieved person, another is a domestic relationship, third is a shared household. Now, when you talk about this act is basically as treated to be a criminal legislation, because it will be taken to the magistrate and the magistrate will pass an order. In case if the orders are not being complied by the respondent, then we take it for the punishments also. A penal liability is imposed under this particular act. So, whenever we talk about any criminal legislation, there the terminology used is accused and victim, but this act is treated to be a different legislation. So, we do not want to make them to feel as a criminal or an accused. So, a word is used is aggrieved person and the respondent. She is not a victim, but she is aggrieved with that domestic violence. So, who is an aggrieved person is explained under section 2 subclause A of the act, which says that any woman who is or has been in the domestic relationship with the respondent and who alleged to have been subjected to any act of domestic violence by the respondent. So, the words clearly shows that aggrieved person means any woman upon whom this particular violence, domestic violence has been committed by the respondent, that is the not the accused, rather he is called as a respondent. Number 2, here when you say he is a respondent and she is aggrieved person, is between both of them there must be a domestic relationship. Now, what do you mean by domestic relationship? Section 2 subsection F talks about the domestic relationship, which says a relationship between two persons who live or have at any point of time lived together in a shared household. When they are related by consanguinity, a marriage, or through a relationship in the nature of marriage, adoption, or any family member living together as a joint family. Now, when you talk about the domestic relationship, here the meaning is totally differently given under this particular act. The relationship between aggrieved person and the respondent must be either a consanguinity, that is the blood relationship, or affinity, that is a marriage relationship, or any kind of relationship which is in the nature of marriage. There need not be actual marriage, but both of them are living as a husband and wife, and if they are living as in a nature of a marriage, that in simple sense we can understand or interpret as a live-in relationship also. And other than the blood and marriage, if a person has been adopted, even the adopted relationship and any relationship of a family member, because family member need not be all the time having a blood relation, even it can be a relatives, like mother's brother is a relative. There need not be a blood relation, but a mama relationship can be there. So, whenever the two persons are related with each other, that is the aggrieved person and respondent are related with each other either by blood or marriage or like marriage relationship or family relationship or adoption relationship, if these two people have either living together or once upon a time lived in a shared household is treated to be a domestic relationship. It is including even the specifically for Hindus where they are living in the joint family also. So, this is the definition, and again from this definition we can draw one particular word, that is shared household. Until and unless these relatives live together in a shared household, we cannot say that is a domestic violence, nor that woman becomes an aggrieved person or a man becomes the respondent. So, what do you mean by shared household here? It says that shared household means where that person aggrieved, that is aggrieved person, lives with the respondent at in any stage or has lived in any domestic relationship either singly or along with the respondent, and includes such household whether it is owned by the respondent or the aggrieved person or tenanted either jointly by the aggrieved person and the respondent. So, the concept of domestic violence will understand under these three important definitions. First thing is, two people must live together, or they might have lived together under one shared household, no matter whether this shared household is either the rented one or own, or it is a part of joint family, whatsoever it is, number one. And this shared household, the respondent and the aggrieved person must be in a domestic relationship. If under this domestic relationship, the third is where the respondent has committed or subjected that aggrieved person with domestic violence, that is cruelty or harassment, whatever the meaning you say, the definition is given under section 3. So, here if these three things comes into picture, then only the actual locus standi or the jurisdiction under this act comes into force. Of course, other definitions are there like protection officers, domestic incident report, who are the service providers, n number of definitions are there, but the important these three definitions only will treat or will take the actual attribute of whether a petition or application can be filed under this particular act. Now, in order to talk about any particular thing under this law, what is important is there should be an instance of domestic violence. What do you mean by domestic violence? That is laid down under section 3 of the act. Now, coming to the definition of domestic violence, which is laid down under section 3 of the act, it says that for the purpose of this act, any act, omission, commission or conduct of the respondent. So, here it says by way of act, where the respondent is trying to commit a particular act, or where he is supposed to do an act but he was sitting idle, that is omission, where every person in a family will have certain responsibilities. If an respondent failed to perform his responsibility and omits that particular responsible act, or if he commission or sometimes through his conduct, either through an act or an omission, either by commission or through the conduct, where that nature of that conduct or an omission or a commission becomes a domestic violence if it harms or injures or endangers the health, safety, life, limb or well-being of that particular aggrieved person, who is obviously a woman. So, this particular nature of a person, that particular nature of a person either by an act or an omission or a commission or a conduct, if it is giving a kind of an injury, or it is harming the woman, injuring the woman, endangering the health of the woman, safety of the woman, limb or well-being of the woman, whether this kind of injury, whether it is a mental or physical of aggrieved person, that amounts to the domestic violence. Hence, it says domestic violence includes causing physical abuse, sexual abuse, verbal abuse, emotional abuse and economic abuse. So, it divides the abuse into 4 categories. where the nature of the respondent through his act, omission, commission or a conduct, if he is trying to harm that woman, injuring the woman or the health of the woman, safety of the woman, whether it is a life or a limb or a well-being of the woman, causing her either physical abuse or a sexual abuse, verbal abuse and emotional, verbal or emotional abuse and economic abuse amounts to the domestic violence.